be silenced.
I've just come out of a committee Thursday night where C-51 was being looked at in the third of its hearings. And I have to say that I came out of there ashamed of being an MP, not for what the NDP and the Greens actually are doing to try to oppose the bill, but by the fact that I have to sit across from Conservatives who use their question with respect to the first Muslim Canadian witness at the committee to leave innuendo for 3 or 4 minutes of innuendo that somehow this person was coming to justify terrorism. It was one of the most disgusting moments I've experienced in my 3 years as a member of Parliament. And all I can say is that Mr. Gardaí, Sam Gardaí, who's the head of the National Council for Canadian Muslims, the way in which he handled that with aplomb, with calm, and with dignity is something that I honestly can't say that I would have done the same in return. This is an awful... This bill truly is a threat, not just to constitutional rights, not just to the rule of law, but also to our very democracy, because we have to remember that this bill, although called in the short title the Anti-Terrorism Act, it's a massive deepening and expansion of the spy state or the surveillance state or the secret state. Now, whatever justifications there are for expanding national security law, none of them have been put on the table by this government as the reasons for going well beyond any focus on terrorism. And even then, when they're focusing on what they think is terrorism, they're doing it in ways that are completely unjustified. There are reasons that we really should be concerned, if not afraid, of what could come out after this bill gets rammed through the House of Commons, unless we're successful in the way we were with the Unfair Elections Act, C-23, and that is to so force the government back on their heels. They're already not expecting the massive outpouring of resistance across this country, to actually force through 5 or 6 major amendments that will at least get us through till after the next election, when hopefully the entire bill can be repealed and stitched back together in a way that makes sense, both for security and all the values we hold dear. Now, let me just tell you 1 or 2 quick things about the bill, because frankly, the list is so long. 2 of my colleagues, Professors Scorsese from Ottawa, University of Ottawa, and Roach from University of Toronto, have written in a kind of guerrilla style over the last month over 200 pages of close analysis of this bill. They are single-handedly most responsible for the awareness of the media and us as politicians of what is in this bill. They all deserve, frankly, the Order of Canada for their work in the last six weeks. What they have detailed, I can only touch the surface on. But here are a few things. There's a new act plunked into this bill. It's called the long title. There's a long title, but the short title is the Information Sharing Act. First thing, as Linda said, the information that can be shared across 17 different government agencies includes a huge, long, open-ended list. It can be added to by the cabinet at will, where terrorism is only one in the list. Okay, one in the list of 8 areas in which information can be shared. They have not included in that sharing circle the review bodies of any of the security agencies, except for the Commissioner for CSIS, which is the Canada Security Establishment. The oversight body that is partial oversight body for the RCMP is not in the loop. And CERC, the oversight body for CSIS, is not in the loop. And the main bottom line recommendation about the Aurora Commissions and the Air India inquiries were that if you're going to have information flow in order to prevent terrorism, you also have to prevent stovepiping and make sure information can flow to the oversight bodies so they know what's going on across jurisdictions. So the Commissioner for the CSIS Commissioner, the Commissioner for Security Establishment of Canada, has just written a letter as well. He probably won't get to testify, just like the Privacy Commissioner, who's an officer of Parliament, is not being allowed to testify, saying, he says, I don't understand why you would so expansively create information sharing out into this kind of total awareness state and not include the review bodies? What's the answer? It's deliberate. It's absolutely deliberate. This government does not want oversight or review of any kind. Now, in that Information Sharing Act, there's a provision that says any recipient, that is any of the 17 listed entities, can share the information they receive, and this is a direct quote, with any person for any purpose. Okay? Any person for any purpose. That includes foreign agencies. It includes anybody outside of Canada. This is what Professors Roach and Forsizi call the anti-Mahar clause. It basically is a, I shouldn't do this on camera, pretend there's one finger going up. That's basically giving the finger to the Arara Commission and everything we know about what happened to him, what happened to Mr. Almaty, Mr. Al-Malki, Mr. Nuruddin. Then they have the nerve to add a provision that says, and by the way, if information is shared in good faith, there is immunity from any civil lawsuit. So the lawsuit that Mr. Moreira successfully brought, there was a settlement against the Canadian government for sharing information with the Americans and the Syrians that led to his rendition and then his torture. Almost certainly it was stupid, it was incompetent, it was callous, but it was probably in good faith. That lawsuit would now no longer be possible, nor would the lawsuits now being brought by the three other gentlemen I named. Another thing they allow is, again, well beyond anything that supposedly relates to terrorism, is a new activity for CSIS in Canada and abroad that we call disruption. They're calling it an understated way measures in the bill, but basically, as long as it's determined by CSIS that something is reasonable and proportionate in order to somehow prevent or get in the way of or disrupt activity, including on anything within CSIS's mandate. CSIS's mandate goes well beyond anything to do with terrorism, then they can do it. If they think that it requires them to break the law or the Charter of Rights and Freedoms, then and only then do they have to go to a judge. But they have to go to a judge and say, can you sign off in advance on violating the Constitution or breaching the law? It's the most ludicrous standing on its head of any proper understanding of the role of rights in a constitutional democracy or the appropriate role of judges. If you're going to ask judges to look at what's reasonable and appropriate, you set out what the measures are in legislation. You have the executive decide whether they're required or necessary in a certain circumstance, and then the judiciary later can figure out whether or not that was justified or you have some other oversight mechanism. You don't turn the judges into agents of the spy state, including in secret proceedings. The proceedings will be secret, and then after the fact there is no follow-up. There's nothing written in to say the judge has to be told what happened to make sure it wasn't abused, etc. Now, there's an absolute limit on what can be done. You cannot intentionally or by criminal negligence kill or bodily harm somebody. That's nice to know. You can't impact on somebody's sexual integrity. I assume that probably has something to do with the spy world's use of honey traps and things. I'm not sure. And the third thing is you can't willfully engage in obstruction of justice. Everything else by way of rights that could be infringed under the Charter are on the table. And including the fact, and here, bodily harm and death does not include kidnapping or detention or the forcible sending of somebody somewhere else. CSIS now has powers around the globe, not just for investigation in C-44, which already is passing, but in C-51 to engage in these disruption measures. When we've asked in committee, all the experts say detention is left open by this language. And then they say, why wouldn't the government specify that it's not allowed? So yesterday in the House of Commons, when one of our members, a critic for public security, Randall Garrison, who's been doing an amazing job, stood up and said, is or is not detention included as one of the possible disruption measures in that broad language? They simply refuse to answer. The easiest answer, if it's not, is to say, no, of course. Why are you so paranoid? No, they don't say that. It's proof that they want it in play. Now, the last thing I would say, frankly, there's so much else in this bill, but one of the things that has been deepened in this bill is preventative detention. which means it used to be that if there's a likelihood that somebody will commit an offense even, we always had peace bonds that would allow that. You can be on a warrant, or in exigent circumstances, you can be detained in order to prevent that, and then a judge can issue conditions for you staying free because you're a threat to somebody usually. It's usually a personal injury or death threat situation. So now under this bill, it's only, you can be hauled before a judge and conditions imposed. If you breach those conditions, you go to jail, and you can be hauled before a judge for 7 days, not before a judge, but in detention for 7 days before the judge has to decide anything, on the basis of the fact that somebody has judged that you may commit a terrorist offense. Now, one of the provisions in this bill is to say that anybody who somehow or other encourages or promotes terrorist offenses in general, nobody knows what that would mean or look like, in a way that could be reckless as to whether or not somebody might then actually commit some offense, then you yourself are a terrorist. Now, the breathtaking breadth of this in terms of what it could be used for, I had an insight into that Thursday night, because essentially what Diana Blancy, the Conservative MP, was doing in that committee meeting when she was questioning the representative of the National Council of Canadian Muslims was saying that in the course of your work, when you're taking issues on this organization or that organization, be careful, because otherwise we're calling you a terrorist now, but under this bill you will become a terrorist. All right? That's effectively what the subtext of that was. So you put the two together, that you recklessly, say something or do something that is reckless as to whether somebody else may commit a terrorist offense, and then you put that together with the fact that you may be preventatively detained if you may commit an offense, and then the threshold for actually pulling people in a preventative detention sweep or regime or threatening people with it in order to achieve other ends, the sky is the limit. So basically, I was about to say regime, and I will say, this is a regime that cannot be trusted. Quite apart from what the analysis reveals about the dangers in the bill, the fact of the government that is pushing it through, the way they're pushing it through, and the way they're refusing to say that some of the worst implications are not in the bill, we have reason to be concerned for the future of our democracy. So thank you all so very, very much for taking the time. Please stay with us. It's going to be your voices that make the difference.